Unlike WA's anti-discrimination laws that are contained in a single piece of legislation, Australia's federal anti-discrimination laws are contained in separate pieces of legislation. This specifically includes the Racial Discrimination Act 1975, the Sex Discrimination Act 1984, the Disability Discrimination Act 1992, and the Age Discrimination Act 2004. The Fair Work Act 2009 is also relevant to federal discrimination complaints in employment settings. The Australian Human Rights Commission Act 1986 establishes the Australian Human Rights Commission. Protected attributes. Under these separate pieces of legislation, it is unlawful to discriminate on the basis of various protected attributes, including age, disability, race, sex, sexual orientation, gender identity, intersex status, relationship status, pregnancy, breastfeeding, and family responsibilities. It's important to note that unlike in WA, religious or political conviction is not a protected attribute under Commonwealth anti-discrimination laws. Under the legislation, the act of discrimination must also be linked to a particular area of public life. This generally includes employment, education, access to places and vehicles, provision of goods, services and facilities, land, housing and accommodation, clubs, sport, administration of Commonwealth laws and programs, and requests for information. We will now go through some key points of broad application that are generally consistent across the different areas of federal discrimination law. Discrimination can be direct or indirect. Direct discrimination is where a person is treated less favourably than a person without their protected attribute would be treated in the same circumstances. Indirect discrimination can be more subtle and is where an unreasonable condition, requirement, or practice has the effect of disadvantaging people because of their protected attribute. If an act of discrimination is done for two or more reasons, and one of those reasons is because of the person's protected attribute, then the act will generally be taken to be done due to the protected attribute, regardless of whether that was the dominant or substantial reason.
It is unlawful to harass a person on the basis of some protected attributes, such as race and sex. Harassment is characterised as unwelcome conduct of a demeaning nature that is likely to cause offence, humiliation, or intimidation. In addition to harassment, the Sex Discrimination Act also makes it unlawful to create a hostile work environment on the ground of sex. Unlike the WA Equal Opportunity Act, where the term racial harassment is used, the Commonwealth Racial Discrimination Act refers to racial hatred and makes it unlawful to perform an act that involves publicly offensive or abusive behaviour based on racial hatred. It does not have to be directed at a particular person.
It's against the law for an individual or organisation to act against or threaten to act against a complainant or potential complainant due to them making a discrimination complaint. This is known as victimisation. Each piece of legislation provides a list of exemptions where discrimination on the grounds of the particular attribute is not unlawful. Special considerations. The Commonwealth Disability Discrimination Act provides some exceptions to disability discrimination in employment. The first exception is the inherent requirement exception, where it's not unlawful to discriminate against someone's disability if the person would be unable to carry out the inherent requirements of the work, even when reasonable adjustments are made to accommodate their needs. The second exception is the unjustifiable hardship exception, where it's not unlawful to discriminate against someone's disability if avoiding the discrimination would impose an unjustifiable hardship on the discriminator. Under the Sex Discrimination Act, employers, organisations and businesses have a positive duty to take reasonable and proportionate measures to eliminate discrimination, sexual harassment, hostile workplace environments and victimisation. This obligation extends to sole traders, self-employed small, medium and large businesses and government. You should consider the intersection between Commonwealth Discrimination Law and the Fair Work Act if the facts arise in an employment setting. Under Section 35 of the Fair Work Act 2009, employers must not take adverse action against employees or prospective employees because of a protected attribute. The Fair Work system only covers national system employers and employees.
Practical tools and tips. Complainants generally bear the onus of proving a direct discrimination claim on the balance of probabilities. Complainants can sometimes face obstacles in accessing relevant evidence to prove their claim, because it is generally the respondent that has knowledge about the decision-making process that led to the complainant's treatment. It is also the respondent who is likely to control most of the information the complainant needs to establish their complaint. Without access to sufficient information or direct evidence, the complainant must rely on the Commission requiring documents as part of its inquiry and/or circumstantial evidence. Complainants could also consider presenting statistical evidence. Given the significant costs associated with federal court proceedings, we recommend that you maximise the chances of a successful outcome for your client during the conciliation process by compiling the best evidence and arguments at an early stage, ensuring that the other side is aware of the arguments and evidence at the earliest opportunity, and advising your client to seriously consider offers made to settle. Another issue you may need to consider when advising your clients is in relation to non-disclosure agreements. It is extremely likely that they will be asked to sign one, but it is important to inform them that they are not required to do so.
Cases. The 2023 federal court case of Gutierrez was one of the few successful employment cases handed down under the Age Discrimination Act. It involved a 73-year-old accountant who was forced to retire in line with company policy. He was awarded $232,000 in damages. This case highlights important issues around retirement and fitness for work. Australia does not have a mandatory retirement age, and employers should refrain from directly or indirectly referring to an employee's capacity or ability to work as they get older, to ensure that they do not unlawfully discriminate. Employers may argue that an older employee is unable to meet the physical demands of a job or lacks the necessary skills due to their age. However, case law indicates that it's important that these arguments are supported by objective, mostly medical evidence, rather than assumptions based on stereotypes about aging. In the case of Muragesu, an employee was awarded $40,000 in compensation for constant racial remarks made by a colleague. Although the employee had complained to their employer about the behaviour, the employer failed to investigate and remedy the matter and was found vicariously liable. This case indicates that employers, having policies and procedures in place to deal with discrimination in the workplace, is not enough. Employers must also take steps to enforce these policies and procedures. In the first racial discrimination case under the Fair Work Act, it was found that an employer had racially discriminated against overseas skilled workers. Their working conditions were significantly different to those of other employees, as they were paid less and had to work longer hours. The employer was found to have deliberately chosen to undercut their minimum work entitlements due to their race, and the employer was fined $211,000. This case sets a strong precedent for preventing racial discrimination in the workplace.
Purvis and New South Wales is an important High Court decision in relation to unlawful discrimination under the Disability Discrimination Act. Purvis involved the suspension and expulsion of a student who had suffered brain damage when he was an infant and, as a consequence, frequently exhibited violent behaviour towards staff and students. The appellant claimed that the respondent had discriminated against the student on the ground of his disability by subjecting him to a detriment in his education and by excluding him from the school. When applying the requisite comparator test, the High Court considered whether the school would have acted in the same way against a student who did not have the same disability as the student but behaved in that same way. The court held that the respondent did not unlawfully discriminate against the student because of his disability, and that the genuine basis of the principal's decision was that the student's conduct posed a danger to other pupils and staff, and the principal had responsibilities towards those people. The appeal was ultimately dismissed. The decision has been widely criticised as it is difficult to apply, but currently represents the law in Australia. Tickle and Giggle for Girls Proprietary Limited is the first case to consider gender identity discrimination under the Sex Discrimination Act. Roxanne Tickle was a transgender woman and was recognised as female under the Queensland Births, Deaths and Marriages Registration Act 2003. In 2021, she downloaded the Giggle for Girls app, which is marketed as a digital women-only safe space and requires registrants to upload a photo of themselves to verify their gender. Ms. Tickle's selfie was approved by the app's AI detection software, but after 8 months she was blocked and could no longer use some of the app's functions. Ms. Tickle alleged that Giggle had discriminated against her on the basis of her gender identity. 2 forms of discrimination were argued: direct discrimination under Section 5B1 and indirect discrimination under Section 5B2 of the Sex Discrimination Act. The court held that Giggle indirectly discriminated against Ms. Tickle by imposing the condition to appear to be a cisgendered female in the photos submitted to the app, which was likely to have the effect of disadvantaging transgender women